Alan, I'll leave it to you to open the meeting.
Yes. So, my name is Alan Plummer, I'm the code enforcement officer, and I'd like to call the meeting to order at 5:59. And if we could stand and pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And just say here for a roll call, Neil Barry. Here. Paul First.
Here.
Terry Kirk.
Say here.
Here.
Milton Simon.
Here.
Byron Philbrook is alternate. We do have a quorum. And just to let the public know, Barbara Schneider has resigned as the chair of the appeals board. So that's effective now. We do need to go through an order of procedure here, but we will need to elect a board chair.
We did that last meeting.
We did a temporary board chair, so.
I make a motion, Paul First be the board chair.
I'll second it.
Any discussion? Nope.
Willing to serve until I possibly, get so busy I can't serve anymore.
What's
So
the
at
gap?
some point, I may call on one of you guys. But willing to serve for now.
Any more discussion? Can I get a vote? All those in favor, raise your hand. All those opposed? Any abstained?
Abstain.
One.
Here's a big dog now.
What's in it?
Here's a big dog.
Excellent, so my job now is over. He's in charge.
Okay.
If we had to
Thank you.
officially vote a chair, do we have to re-vote the secretary?
I don't believe so.
I don't believe
The
so.
the chair was a temporary.
Yes.
Okay,
I think that's right. Okay.
stuck with it.
Welcome, everyone. So I think our first order of business here is with regard to, it's been such a long day. You're just going to have to remind me of your name again. Byron,
is
of
the
course,
right name.
Byron.
Yep.
Yes, okay, so Byron. Byron, you are currently serving as our alternate. I would ask for a motion to allow Byron to serve as a regular member
So moved.
in the absence of Barbara Schneider for this evening's meeting.
I second.
Yep. Okay, discussion? All those in favor? Okay, so, and abstaining?
Abstain.
Yep. And opposed? Very good. All right. And yeah, I was a yes for that too.
So 4-1 abstain.
4-1-0. Okay, very good. Okay, so our next item of business is minutes. And if someone could provide for me the date of our last meeting, does anyone have the date?
November 21st.
November 21st. So I would ask for a motion to accept the board minutes of November 21st.
So moved.
Second.
Discussion? All those in favor?
Thank you for doing
Excuse
those
me.
minutes.
Do
Yeah,
you,
thank
do you
you,
have a
yeah.
copy of those by chance?
I do,
I'll sign it.
yes. You have a copy on your table too.
Oh, okay.
Okay, so this evening, we have a new appeal. And this is from Jamie Tarigny?
Tarini.
Tarini, okay, very good, thank you. Excellent, and she is represented by Attorney Zuckerman.
That's correct. First name is Larry.
Very good, okay, by Larry Zuckerman. All right, so, and this appeal pertains to a piece of land that she's purchased and the dimensional requirements in the ordinance. And it also pertains to the ordinance change from last town meeting. That's my understanding. What we typically do is we let the CEO just kind of give the overview of the issue at hand, and then we ask the appellant to give a statement.
Okay.
if that sounds good to you guys.
Yeah, and the only thing I would request, and this is in the interest of all our time this evening, is that the submission that I previously made, including the exhibits, be treated as part of the record, apart from any oral testimony that might be given or further statements that are made, in order to shorten up what the record would be, unless anybody has an objection to any part.
We'll make sure that's reflected in the minutes, and it seemed like a thorough package. Thank you. All right, very good. So Alan,
Yes, as the code enforcement officer for Durham, I had an appointment with Jamie and her sister, I can't recall. Kelly. They needed to get a zoning determination for a parcel at Kelly's property. In order to possibly split it, the bank required that. Kelly owns the parcel, and the bank, she has a mortgage on it, and the bank needed to release a portion of it so that she could split it off. So I looked at that parcel, looked at the requirements in our land use ordinance. There seemed to be a buildable area. It may have been, it could have possibly been in the flood zone. However, you can build in the flood zone if you build to flood standards. And I did note that in the letter that I gave them. That letter, I believe, was on March 8th. Is that right?
yep, March 8th.
Yep. And at that point in time, I looked at the zoning that we currently had, made sure that there was a building envelope available, that it wasn't in any restricted zones, and it looked like, depending on the size of the house, because I can't determine, I can't say you can put any house there, because if it's 90,000 square feet, that probably wouldn't work. But there is a potential to put a house on this parcel. So I did issue that letter, and I put that in the file, gave that to Jamie. And they did whatever it is they did. And you found some of the evidence of what they've done is in the packet that you received, and they can clarify what they've done after. The next I heard from them, I believe, I may have had a phone call or something, but I don't recall that. The next time I heard from them, Jamie came in to give me, I think you brought in a septic design. You bring a septic design in? or
No,
not? The building permit, so
that's incorrect.
okay,
At that time, I think that was for readiness to go ahead and obtain a building permit
building
once
permit.
plans were
yeah,
submitted.
yeah, so, a building permit, and I brought up the parcel, as I always do, and at that point, which is after our last town meeting, the resource protection zone had changed. And I said, there's a problem here. So you need to have a building envelope of 40,000 square feet that is outside of the resource protection zone. So unfortunately, I can't give you that at this time. So I denied her, she asked for a letter, and I wrote up a denial for a building permit based on the evidence at that time. I always have to go with the ordinance as of today, the day that someone is talking to me. That's the ordinance I have to go on, and that's what I did. So I informed her that she's available, has available the Board of Appeals, and she's entitled to appeal my decision, and that's what she's done. Did I leave anything out, or do you have questions about it?
What's the difference in the square footage? What kind of order of magnitude are we talking?
Significant, there's not even a, I don't have the number with me right now, but I could not even get anywhere outside of the resource protection zone, anything close to 40,000 square feet.
Uh-huh.
Before that, there was a large, very large area.
I see.
Comparatively.
Okay.
Not extremely large, but big enough for 40,000 square feet, which is all you need,
Uh-huh, okay,
yes.
okay, very good.
Well, your memo said 15,000 square feet was available.
15,000.
Yeah, okay.
Thank you.
Great, thanks.
Thanks. Okay, if I could also ask Larry, after giving your statement, if you might be willing also to talk about just briefly how you and the appellant feel this case should be heard. Whether you think it should be heard as an administrative appeal
Yeah.
or a variance.
Ah,
I noticed in your letter that you offered up both options.
yeah, because I really believe that this case, while it certainly fills the requirements of an estoppel action, it also, I think, under your ordinance qualifies for variance.
Right.
And the point here is, we ought to try to achieve at this level something that works for both the town and the applicant in this case. And I give some kudos to Alan, because in his November 27th letter, what he indicated in essentially denying at that time the zoning determination, he said, the only thing, you qualify in every other regard, whether it's lot size, whether it's setbacks, even for that matter, being the area, small area out of the floodplain that would be usable. So what I think he was saying is, if the old ordinance would have been in effect, then I certainly would have granted a building permit, had plans come in that complied. After all, if you think about the average house, what is it, maybe 1,500 to 2,500 square feet of living space at the most. You add a little bit for a garage. And there's no question this any plan would have hit on that zone. So now we come to the question of equitable estoppel. And the reason I bring this up is because it is actually a fairly clear case to me relative to Jamie's circumstances. And let me sort of recount the facts that are in the submission and add a few more that will be helpful. I think the first thing is that Jamie, who has been a lifelong town resident, but rents now. She has 3 boys, one of whom lives with her part of the time and lives with his dad the other part of the time. She would like to build a house. And as we all know what's happened in terms of the marketplace, it has gone right through the roof. So to be able to afford a lot in Durham is a tough go, no question, let alone is there any inventory for sale. So what happened was Kelly Burnham, who is Jamie's sister, said, okay, look, I'll sell you 2 acres of land that complies, and we can go in, see Alan relative to what we need. And what Jamie did is, she had a survey done, she had a site analysis done, including the septic design. Alan was able to easily determine the elevation for the parcel. This is on, I believe, March 8th or maybe a day or two before. And by the way, that if you take a look through the exhibits, all of that is included. And so she went ahead and did everything she needed to do that she could do on March 8th, because what her plan was over time, with limited resources, is to pay Kelly over a period of time. And in fact, she went ahead and made her first payment of $6,500 on March 22nd, prior to any change in the ordinance. And I would submit to you that if you were reviewing or part of the planning board and you said, look, do you have an interest in this property in order for you to have standing to be heard? The answer is yes, because what she did is start purchasing that property back in March of 2023. Further, the only thing that she could do on a legal basis was to request of the mortgage company a release for that 2.08 acres that is part of the survey. And mind you, bearing this in mind, that everything else complied. So what Jamie did was go ahead and do everything she could. And again, in the exhibits, you'll see the payments that were made to, I believe it's JP Morgan Chase Bank, which I think is out of New York, but the payments may go to Kansas or South Dakota, I don't know which. and did everything that she could at that point. And the reason both Kelly and Jamie went in to see Alan was to get a letter approving the parcel as a legitimate lot so that they could request of the bank a release, because otherwise Kelly would be in default under her mortgage. And that's what they did. And as typically known by everybody, what happens is banks, particularly large banks, take forever to approve something. But finally, on June 30th, after money has been spent, payments have been made, they finally say, yes, we'll give you approval, here's the release. And so the next step is, of course, get the title search, go ahead and get a deed made up, which was done. And I think the deed is dated August 14th, that's when the closing occurred, to go ahead, convey the property legally. But remember, she had an equitable interest in this property back in March, and she did everything possible that she could have done at that point in time prior to the change. Now, how do we come up with equitable estoppel, and how does that apply? Well, the first thing is equitable estoppel is a equitable law that basically says if you rely on what someone has told you or an action that they have done, provided that they are authorized to make that statement or make that decision, and you rely to your detriment on it, then in fact an estoppel, or if you will, a stop order, should apply to prevent the enforcement of something that occurred through no fault of the person's own efforts, so that an unfairness doesn't occur. And what's interesting about this particular case that I found, because I cited a case from the city of Auburn, it is the last case that I cited. And what happened in that case is someone bought a multiple business. They had a gift shop, they had a nursery, they had a landscape business, they sold some other things. And the code enforcement officer came out and said, look, if you want to do this, you have to go to the town council or the city council and get a change of zone. And what you need to do is change it from an urban residential zone to a business zone. So these people went ahead, spent a lot of money doing this. They were spending a lot of money on their business, and went to the city council, and lo and behold, the business zone was approved. And they went ahead and started operating their nursery and landscape business in addition to all these other businesses. Next thing you know, the code enforcement officer comes out and says, I hate to tell you this, but even though we never discussed this, a nursery business and a landscaping business are not allowed in this general business zone that got approved by the council. And so what they did is they then appealed to the Board of Appeals. They were turned down. They then filed their action in Superior Court. And Superior Court came back and reversed the decision of the Board of Appeals, because what they said was that in this case, the people went to the code enforcement officer and spoke with him and said, what do we need to do if it's not proper? And he told them, yeah, well, you gotta make it a general business zone. He didn't tell them that it's the nursery business and the landscaping business were not included within that zone. The city, so the Superior Court ruled in favor on the basis of equitable estoppel. The city appealed that to the Supreme Judicial Court, which is the highest court in the state. And the highest court in the state reviewed the facts. They can't change the facts or take new testimony. But they came back and said, you know what, out of fairness, these people ought to be able to operate their business because they relied on someone who was authorized to make decisions, ought to be able to believe what that person said, and acted to their detriment. And the biggest piece is, had he told them way back when, they would have never have gone ahead and opened up their landscaping and nursery business. So that's equitable estoppel on a case that exists. And in that situation, what the highest court in the state said was, we're not going to allow the city of Auburn to enforce that portion of their zoning ordinance. So in this case, what I am asking you on behalf of Jamie is, don't enforce against her this new zoning change, because if we take a look at the facts of this case, you know, Jamie went in to see Alan in a very timely way, never received any written notices from anybody or the town regarding changes that were occurring in terms of zoning that might affect her. And relied on this letter in order to make that change. And if we take a look at where we are right now with this matter, realistically, if you look under your variance requirements, it satisfies all the requirements of the variance. Because, you know, it's within the setbacks, there's a septic system that applies, a well can be drilled.
Yeah.
All of those things.
Not at the fault of the owner.
Not at the fault of the owner, and
Exactly.
to be honest, not at the fault of the CEO, because
Sure.
the CEO
Right.
didn't discuss a zoning change, because who knows whether that zoning change would have been voted in. But the key was here, which I think it makes it compelling, at least to me, and similar to the case with the city of Auburn, is that really everything that could have been done prior to the zoning change was in fact done by Jamie. And a lot of money was spent. So, the best solution, I think, for the town and for Jamie would be to either one, grant the variance if you feel that's more palatable, or accept equitable estoppel in this instance and not enforce the zoning ordinance that currently exists relative to this particular lot, but rather simply apply the zoning ordinance as it existed prior to April 1.
So, yes, Jerry.
Alan, was this piece of property that we're looking at in existence before town meeting of last year?
Are you talking about the parcel that was split off for Jamie?
Yes.
Survey, right?
It had been surveyed, and that's what I saw.
If I could, in my view, that's why I pointed out equitable interests. In my view, it was split because Jamie had an equitable interest in 2.08 acres prior to that town meeting. And she would have had standing to come before any board or planning board as a result of that equitable interest.
So Terry, what I have to do, I understood that there was a change, there's a possible change coming for the town meeting, and I can never look at that possible change. I can't answer questions about it,
Well,
because I have to do with, I looked at what was in force today, so I wasn't concerned about that. I knew that, I had an idea that there could be a change, but how do I don't have a crystal ball to know if that was gonna pass or not. So I looked at that parcel as if she wanted to build tomorrow. And I had to answer because she needed, I don't like giving those letters, but they needed that letter for the bank, is why I gave it to them on that date.
But my question is, does this piece exist before town meeting?
The survey existed before town meeting. I saw it.
I'm thinking, and maybe you guys could help us with the chronology here. because I saw, I think, a deed that was prepared for the mortgage release in late March, before town meeting. So I'm assuming before you can apply for the mortgage release, you have to have the survey done.
Right,
Okay, and so when did you apply for the mortgage release?
that was applied, I believe, on March 22nd, before
Okay.
the town meeting.
Uh-huh. And so, when you do that, do you also draw up like a draft deed?
I don't know the answer to the question
Yeah.
of whether a deed was drafted, but I believe it was
Yes.
because on June 30th, when they responded with a letter, they also gave a release deed.
Uh-huh.
And
Yeah.
that was dated June 30th as well.
Yeah, yeah, okay.
So what's the answer to my question?
I think it depends on how you look at it. I think it depends on how you look at it. If you look at it from this legal perspective of, did the appellant have legal interest in the property? I would say probably yes. Did the lot officially exist, like on the town's books? Probably not. So I think it's both yes and no.
Oh, God, I agree.
So I had to kind of look in the future there. The reason that I gave it, as I said, I don't like giving those letters. Code officers want to stay away from those letters. But they can't go to the bank to get a release without this letter. Therefore, I have to make a determination. I had to do that. At that point in time.
What was the change in the zoning? It was just an expanded floodplain?
No, a resource protection, rezoning of resource protection. Some parcels, some people in town gained from that resource protection change, other people,
I know, but there were several things that happened. Was it just an expansion of the zone? What, was it because there was also some, that organization that was looking at wildlife and so forth?
Yeah, these criteria.
the different criteria. More accurate data is where the change stemmed from. More accurate data and depiction on mapping and the mapping of the different criteria for the resource protection. And we have 6 criteria,
Which
for
changed
that.
the floodplain.
which changed, yeah.
Yeah, so did that, our new resource protection district, could you remind me, that doesn't allow single-family housing, is that correct?
It's always not allowed it. So if I
Oh,
had
yeah, it's
seen
always not
resource
allowed, that's
protection
right. Yeah.
there, I would have
Yeah.
said, when she came to me, no,
Uh-huh.
you can't do that here.
Yeah, so that new resource protection impinged on that envelope?
Yes.
Okay.
Yeah, if I may, a couple questions. First of all, why the shape of this? This seems like a kind of an unusual plot. Any reason why it's shaped the way it
Is it
is?
asking me that?
Anybody, whoever can answer the question.
Can I answer that?
Sure.
So, there's like a little, I call it a perennial stream that runs behind where she would build her house. And it just keeps going to her house, behind her house. And that little piece that comes up is all like, we needed to add it to make it 2.08 acres. So she would have enough land. But the reason it went that way is it's not wet up there, because the little stream just goes straight out towards Quaker Meeting House Road. So we made it that shape, so it wouldn't impinge on my horse pasture, because my horses and cows need back lot, where the land is not, there's not like a stream or a flooding area. Because when that area does get wet, all this rain we've had, it all comes onto my land. Her little lot is completely dry. I told her she should take pictures, because I drive by it every day, 3 times a day. And that little area is always dry. The water comes when there's lots of rain, like further up towards my house and into my horse pasture. So that's why we shaped it that way.
Alan, are you able to, like, could we put a dotted line or something that shows where the resource protection area is and where it ends?
I could, it covers, I can print something out if you'd like, but it covers the majority of the lot.
I can show it, I can show it to you on a map if you want.
Yeah, sure.
But it does go, I mean, cause I'm looking at an area of 90-something square feet, and you figure, well, there's gotta be a spot somewhere in that, in 2 acres, that
Covers,
you
it
can't.
covers the whole lot.
Covers the whole
almost the
lot.
whole lot.
And it didn't cover the whole lot prior to that.
Zero. It didn't cover any part of the lot, when she came, initially.
And why was it added to resource protection?
I don't know the answer to that. I don't know that specific lot and the reason for it added. The planner has those details, and I don't get into those. They just tell me,
Yeah.
this is resource protection and these are the rules.
Yeah, I'm not sure we can go that far back with regard to why it was added, but we assume it met whatever the criteria was that the planner was
Wouldn't the
using.
floodplain have something to do with resource protection?
Well, it's not only the floodplain, it's probably these other criteria too
Oh, yeah,
related
right.
to habitat, but it
'Cause you
could well have
can-
been floodplain.
If it's only floodplain, she could build in the floodplain.
Well, if you kept it high enough.
But in resource protection, no buildings are allowed. In the floodplain, you can build to 1 foot above flood elevation, and that's fine.
Yeah, I fear if we go in that direction, you know, to looking at why this was determined to be resource protection, that could be a really long road to go down to try to determine that. I'm not sure if that's going to be an effective way to look at this.
I don't think that's feasible.
Think it's, you thought maybe it's feasible?
No, I don't think.
Oh, don't think, yeah, I agree, yeah. Yeah, I think we just have to assume, you know, that that's what it is, we have to take that.
The reason I was asking about the lot,
Yeah,
okay, is if this lot existed before town meeting of last year, before the zoning ordinance was voted in,
Again, it depends on the way you look at that. If you ask, they came to me with this idea, with this picture, with this idea, and this lot, and they needed me to determine whether a home could be built on this today. And I looked at it with all the parameters that I needed to, and gave them that letter saying, yes, this is an acceptable lot today. You can, depends on, I'm very careful, depends on the house you put on it and exactly where you put it on it. But yes, there's a buildable area here. So I am determining, I'm not saying that I can't create lots, I don't have the authority to create lots. But I have the authority to make a determination as to whether a house can be built on this area, which is a proposed lot. And they can't move forward unless they have something for me. It's like the cart before the horse. They can't go to they couldn't get the mortgage company to release that portion without a letter from me saying this is a buildable lot.
it wasn't registered in the registry of deeds, but as Jamie's attorney has said, as Larry Zuckerman has said, she had an equitable interest in the lot. So from their perspective, I think the lot existed. Is that
Right.
correct?
Yeah,
Yeah.
in fact, if, for example, this matter had been, say, before the planning board, the planning board would have treated it as a lot because of the equitable interest. And from that perspective, the lot existed.
and I have another question.
Go ahead.
Okay. This lot, before town meeting, how much of it was in resource protection?
None. None. That I can remember. I don't have the map in front of me, but
There was zero.
yeah.
It was in the 100-year flood plan, but there was
Yeah.
zero resource protection.
So resource protection, there was more than enough room for the 40,000 square foot buildable envelope.
would this be grandfathered?
I don't think, I'm not sure grandfathered is exactly the right term. I think it may be more this question of this equitable estoppel or variance as they presented. And, I do think the other piece here is, I certainly appreciate what Alan has said with regard to giving his opinion as of the date that the appellant came in for determination. The other side of the coin is that, I do think we want to try to be good partners. And this is a interesting situation where, March 8th, we had a determination, and then I believe April 1st, the new zoning ordinance passed. So this was only 3 weeks later. And was there any mention of the zoning ordinance,
No,
that it was being considered?
none.
Okay. And, this stuff, this happens, I think we all know this happens. It's, town governance isn't always this neat and tidy thing. There are always things that happen that are kind of outside of the box, and this appears to be kind of one of them.
So I will bring up a point that anyone can split off a lot, and they don't need to come and see me. So if Kelly owned this property and didn't have a mortgage, she could say, get a surveyor, plot that out, split it off, sell it, whether it's in resource protection or not. And she could have come to me and said, I'd like a building permit, please. At that point, if it were in the resource protection zone, I would say no. If it didn't have, prior to the change in the resource protection zone, I would say yes. So she's done a lot of work and did everything she should have done and is not required. There are lots of people that split off parcels and don't check with the code officer first.
Let me ask you this, based on that. So if she had done this the way that you're describing now and come in and got a building permit from you on March 8th, what would have happened on April 1st?
She would have been grandfathered.
Yeah, dang, right, yeah, absolutely.
That's what I can't wrap my head around.
She would, if that had happened, she would have been grandfathered.
The permit was in place.
Yeah.
So, I just wanna review the course, some dates here. So, it was on March 8th that you gave her the requested letter so that she could proceed and approach the bank.
Yeah.
All of her actions after that, and Larry, correct me if I'm wrong, everything that happened after that, whether it was payments, whether it was, relations with the bank, whatever, all occurred after the April 1st. Is
No.
that correct?
No, March 22nd, she sent in the letter and the application to the bank to have the mortgage released. She made a substantial payment for the cost of the lot,
On March 27th?
March 22nd, yeah. And that's in the materials that I submitted.
Okay.
She, at that point, there was nothing else that she could do other than wait
But
for the bank's response.
So I just want to just reiterate that a payment had been made on March 22nd. There was already communication with the bank. Okay.
Right. Payments to the bank were made.
I have this lot up if you wanna see it.
Then we had also had a septic test on February 28th, I guess before you even came in and spoke
Right.
with Alan. Oh yeah, here's the survey right here. See a date on it.
What's the date on the survey?
All the surveys are dated, I believe, February 28th.
Oh, yeah, no, February 20th or 28th, yeah, exactly.
So had there not been a mortgage, Kelly could have, this whole thing could have occurred, and when she came to see you on March 8th, she could have been applying for a building permit
And receive it.
and received it.
Right.
But because there's a mortgage involved, the bank involved, then you have to go through that process, and the bank sort of holds things up, stalls the
They take
process.
time.
Yeah.
So
The
where-
other thing I would mention also is we don't know relative to this change in zone, whether this was recommended by whoever recommended this change based on aerial photography or actual on-site data. And I'm willing to bet that it wasn't from on-site data, because I think this was sort of a wholesale change for the entire town. And I only mention that because, again, from what's been described to me, with these past two storms that we've had, which had a lot of water and rain, Jamie's lot had substantial area where it was high and dry.
I've done a lot of work over there already, cutting trees, clearing. So it's dry.
With regard to equitable estoppel, is that within, do you feel that's within our jurisdiction as an appeals board? To,
Absolutely.
for example, say that, make a determination that, how should I say, that the decision of the code enforcement officer was in error. Or just, we can't really say it was an error, because
No,
he interpreted the
Not an
ordinance
error.
No,
correctly.
I think
Yeah.
what you can say is that the appeal is granted should you feel that way. And that, in fact, in this instance, the code enforcement officer should not enforce the zone as it changed on April 1, but rather apply the zoning ordinance as it existed relative to this lot prior to April 1.
Based on the principle of equitable estoppel.
Or variance. And what's interesting about variance, if you look at each and every of the four items that are mentioned, the
Yeah.
first one is good cause. Is there good cause to do something here where it would otherwise be an unfairness to the applicant who's seeking to do this? And in this case, I think an unfairness has occurred, not through intention on her part, or for that matter, Alan's part. The reality was, once the potential of a zone change was never brought up, never discussed, never noticed, then at that point in time, you have to consider estoppel applying in this case. And this is where it should apply, rather than costing Kelly money for me to appeal to the Superior Court and for the town to pay its attorney to perhaps fight it, I don't know. But it seems to me this is the place to work it out, because in the zoning ordinance itself, I think, the concept of equity exists. That's why there are the opportunities for variance.
Yeah, so, one thought I have is that according to the ordinance, if we're looking at an administrative appeal, then that's not a de novo appeal. So we're not able to consider new evidence. We just have to consider the evidence that the administrator, the code officer, had in front of him when he was making the decision. And I don't know, and, you know, I see a lot of fairly compelling evidence here. So I think it does make sense for us to decide what road we're going down with regard to, are we talking about a variance here, or are we talking about something else? With regard to the equitable estoppel, I'm new to this charge here as board chair. And of course, we've been so fortunate to have the service of Barbara Schneider and Gary Wood over the years, who would have just like seen right through this. But a little unsure how equitable estoppel applies with regard to the board. My assumption would be that it would be more of something that the selectmen would be able to engage with the municipal officials, such as the selectmen, that it would happen that there would be some type of instrument or agreement, equitable estoppel.
Yeah, I don't think so. I think
Okay.
you clearly have jurisdiction here.
I see.
Hence the case that I cited,
Yeah,
because very fairly, Alan, in fact, is the code enforcement officer. He's the one who's in charge of making the decision, and what's appealed is
Yeah.
not the March 8th
uh-huh,
letter, but the November 27th letter in which he says, gee whiz, there's nothing I can do.
uh-huh,
So that's what's appealed here, and I think it's well within your jurisdiction. Which
Okay.
is why, in that case I cited, the court ordered the city to have the code enforcement officer go ahead and not enforce the ordinance.
okay.
So I'd like to comment on equitable estoppel. It's a
Sure.
term that code officers are very familiar with, and
Okay,
exactly why
Yeah.
I don't cherish giving a letter saying, you can do this.
Yeah.
I don't like doing that. I try not to do that. There was no question that I had a responsibility to them when they asked me for that letter to do so. They explained to me what they wanted to do. I had to give them that letter. It's my job to give them that letter. Because of timing, I gave them that letter before the meeting, the annual meeting, where they voted on a new resource protection zone. In good faith, said, you can build here.
Yeah,
And also in good faith, when they came back, after the zone had changed, I can't speculate on whether a zone is going to pass or not in a town meeting. I can't do that. So bad timing, they came after that, and I had to also say, I'm sorry, but now I can't give you that building permit. So that equitable estoppel is in my face. It seems very clear, because of timing, that would be an issue for the town down the road. It could be an issue for the town down the road because of my letter, initial letter, and my subsequent letter saying I denied it. It's, the estoppel part of that is, I told them, yes, you can do this, and you can proceed, because there's a building area here. And they did what they needed to do because they had my word on that.
So you're in agreement with the appellate?
Yeah, I have no authority to give her authority, to give her permission to build,
Yeah.
but I do agree with the appellant.
do you have an opinion with regard to where this belongs, whether it belongs as an equitable estoppel action, or whether it belongs as a variance?
I think the wording, so don't get me wrong, please don't say that I in error gave any letters, because I don't want to be
Of course,
judged
yeah.
like that. But I think equitable estoppel is a very likely, if you were not to grant an appeal for this particular instance, equitable estoppel would continue on. I think this gentleman would continue on with that case and probably do something with that with the town of Durham, past this appeal process.
Yes, but wasn't my question.
Okay.
So-
I think that probably is the direction to go, is the equitable estoppel, because of that. I gave her permission, she moved forward, and the timing says now I can't let you build here. they've spent money, they've done,
Yes, exactly.
They've-
I mean, for me, that's kind of the key, is they have these, she took on these contractual, you know, whether they're written contracts or oral contracts, but she took on these obligations.
Yeah.
She took on these obligations based on your letter. And she took on those obligations between the time before town meeting,
Mhm.
before the time that the zone was
Yeah.
changed.
right,
And that those obligations were fairly substantial, okay? They were a payment, they were of course, the septic test, the survey, a draft deed, having an attorney draft up a deed, and the mortgage release letter, all those things.
And payments to the bank for the mortgage release.
And payments to the bank for the mortgage release, right? I don't know who makes those, that's probably, might have been the.
Well,
boroughs.
no, it might have been Kelly, but reimbursement
Ah,
was then
yes, of
made
course.
for that, and again, on the same date, March 22nd.
Yeah.
I'm just thinking back to a previous appeal. And you were saying, you know, which road, we're kind of, in the back of our minds, deciding which road to take
Yeah.
between the two. So, looking ahead, there's gonna be a day where this property is gonna be sold again. And so I'm wondering if that is going to create an issue when she goes to resell this property. The fact that it went through this appeal process, and whether it was granted by variance or granted by the equitable estoppel, is that gonna affect when she tries to sell this property? And
I
that
don't
may-
think so, because she's gonna proceed, if you were to grant her an,
Mortgage loan inspection, let's just say, mortgage loan inspector comes out and says, looks at the property and says, well, yeah, everything looks good, but, you know, the interesting thing is this whole property is in resource protection. I see here in the Durham ordinance that single-family housing isn't allowed in resource protection, right? So, and there's nothing in the registry of deeds that shows that, that a decision has been made to the contrary. Is that an issue?
No, and the reason would be is, let's say you had granted a building permit and the house was built prior to the ordinance change. Now the ordinance changes, it's in the resource protection zone.
I see.
Does it make a difference? No.
Uh-huh. Yeah.
And on the mortgage loan inspection, usually, as I understand it, they're only looking to see that the house is within the bounds.
Yeah, exactly, or setbacks.
So we should be fine. in
Yeah,
that
okay.
regard.
All right,
There's already houses that were out of resource protection and now are in resource protection when the ordinance was changed.
yeah,
That's already happened.
and houses that
Weren't,
were built before resource protection was established.
right. So I have a question, Mr. Chairman.
okay. Neil?
Yeah, just ignore.
No, I'm not gonna ignore it.
So
Okay.
I made an assumption this was a floodplains issue. It's not.
No? I.
So the appeals under the floodplains management article in the ordinances does not apply.
We don't know, do we? We don't know if the reason it's in resource protection is because of the floodplain boundary or other factors. Is that correct?
Correct.
Okay, so we don't know if it's floodplain or not.
But you can build in the floodplain, is what I'm saying.
But there are requirements to do so.
Yes.
And
Oh, yeah.
if we're giving a variance for that, which I guess if it's the estoppel approach or not, there's responsibilities on our behalf to let people know about flood insurance, et cetera, et cetera.
Right, and all other ordinances would apply. Every ordinance that's here, if they were going to build in the floodplain, I would require them to build to base elevation plus 1 foot.
So you have to investigate that?
Are
They would,
asking
they would
do
have
it?
to, if they were gonna put it in the flood zone. If they were gonna build in the flood zone, a single-family residence, well, you can build accessory buildings or single-family residence in the flood zone if you build to 1 foot above base elevation. They would be required to get a permit from the town, first showing base elevation and the point where they've marked that and where they're gonna build to, and then 3 other inspections by a surveyor for the flood zone,
Who lets them know what's the flood zone is my question.
the surveyor. A surveyor would determine where that would be, where they have to build to, the point that they would
That
have to
was
build
already
to.
done. There's an ERP pin at my site for elevation already for the flood zone.
Oh, so it is in the flood zone?
Yep,
Oh, okay.
yep, it's in the 100-year
100 year.
floodplain.
Right,
Yeah.
right, right,
Yep.
yeah, okay.
Okay. Um, So we don't think that it has a building envelope or a 40,000 square foot building envelope outside of the floodplain?
No, and I just saw my letter, it's 15, there's only
Right.
1,500.
Well, I'm not talking about resource protection.
Oh, out of
it's
the flood, right.
Floodplain.
There could be. So as I said in my initial letter, there could be outside of the flood zone, but they can decide to build outside of the flood zone, in the flood zone, or
Uh-huh.
whatever. But if they're in the flood zone, they have to build to
Okay,
1 foot.
so
above.
maybe it's not relevant for
Right.
us in this decision.
Is the dock here the flood zone?
No, that's resource protection.
Or
That picture, I believe, is the resource protection area. No. That, it could be the 100-year flood mark, it could be. I'm not sure of that, Matt.
Well, I'm assuming that the dark black here is a flood zone, and the lighter gray is resource protection.
I can't answer that with that picture.
What is the green on the map?
You can change the lighter green is resource protection. And you
He
can
has a
change,
picture from us.
you can change the
He has a picture.
filters that are on or off to show. It's not a quick process. There's a, in the upper left-hand corner, you should be able to see that there's some markings. So if you,
So this area here is where she is,
is this our GIS map?
yes.
If you
No,
zoom in.
no, it's not, this is GIS, this is GIS.
Okay, so you need to be to GIS and find her parcel.
It's right,
Yep.
where-
It's right here, this one right
Yeah.
here. So right here, click that.
This,
Nope, right, yes. Choose that top, that check mark right here. No, over, this way more. Yes? Turn on layers, the top one. And you can see the different layers over there that you can add or subtract.
I was looking at a more simpler map.
Well,
Okay.
it's not simple.
Well,
Yeah, I know,
maybe
yeah.
this would be a good opportunity now to ask if there are any other comments from the public regarding the case, because, I think we're actually required under our ordinance to give the public an opportunity to speak about the case. And so I believe Kelly Burnham,
Yes.
you had already made a few comments. Do you have anything else you'd like to add to your comments about the case? And if you do, I would ask you to come up to a microphone.
Sure.
And,
I would just like to add that, I'm just gonna pull this over, that I never would have, that's probably not gonna work. Is this okay?
Sure, absolutely.
So when we decided in like January to get this ball rolling,
Mhm.
we had to have the maps drawn, the deed description, all of
Yeah.
those things done before we even came to Alan, so he would know what he was looking at. That was in the beginning of March when we finally got here. We didn't know in April that this changed. And kept getting burn permits and working on her land. And, I would be in a butter, of course, and this is Valerie, my neighbor, that would be her other side of her. And I just wanna say that area, like, I was all for voting for like resource protection and like protecting our town of Durham. I actually helped vote that in, I believe. And had no idea that I wouldn't have gone to this route, I guess, I was trying to add, to help her build there. I wouldn't have gone to the bank and, you know, gone to this process. It just seems like from March to April, it was just shocking to find out that we worked so hard up till, I don't remember when we got the deed finally in her name and was so happy and excited. But it just was such a letdown when she came in October to get her driveway permit and was denied. That's how we kind of found out that this was a problem, and it was very traumatic to me. I had a very upsetting conversation with Alan. I like totally flipped out because we had been working and just waiting on the bank and waiting for this and waiting for the guy to come and talk about putting in the driveway. And then I come home and the town was there, the road commissioner was like, yep, the driveway is gonna be good. Come up to get it signed and was like, oh, no, we can't sign your driveway permit. Well, what do you mean you can't sign the driveway permit? Because we're not gonna give you a building permit. I just wanna add that it's been a horrible time, and I hope this works out for my sister. I'm sorry to keep you any longer.
That's great, thank you.
And I believe
Okay.
the lot is worthy of a house.
Let's see, Valerie, did you have any comments?
Yes,
Careful sitting down.
Come on up, and if you could just state your name for the record, please.
I am Valerie Good, and I live at 184 Meadow Road,
How do you spell your last name, Valerie?
G-O-O-D. So my land abuts Kelly's and would also abut Jamie's. I know that if I was in the same case, this same issue, having spent money, time, and energy, to have my dream crushed because of it being changed within a few weeks after I was told I could, that would be devastating. And so I'm putting myself in Jamie's spot of, I wouldn't like that happening to me. I've spent lots of money, resources, I had my hopes up, I got all of this, and now I can't. And so, yes, it's not a grandfather type of thing, but it kind of was to a point. And her land doesn't get any water, so I drive by it too. There's no water there, and it's definitely a buildable lot. So, I would really like to be able to see her have her dream of a piece of Durham of her own.
Thank you, Valerie.
Yeah.
Just for the record, and for the public who's watching, as much as I appreciate the emotional point of view, we can't take that into consideration. Our role is to simply look at whatever facts are presented to us. We have to really keep our emotions apart from this. So I just wanted you to be clear that whichever way it's decided, it didn't mean that we were moved by your presentation or we were not moved by your presentation. It has nothing to do with you as residents of Durham. We're all residents of Durham, and so, but our role, we have to leave the emotion out of it. We're just strictly looking at the facts that have been given to us and have to make our decision based on our deciphering of the facts. So just hope you understand
That said, we still have appreciation for your comments and the additional context. Okay, so, where are we? As chair, I don't like to make motions. I'd like to leave it to one of you to make a motion or to, flesh something out. I don't know if there's still questions here. But I think we've heard a lot of the facts. And, of course, again, this could go two directions. This could go as the administrative appeal, based on this principle of equitable estoppel and the fact that that we feel that the appellant has a demonstrated interest in the property or in the lot. It could go that route. It could go the route of a variance.
So, Mr. Chair, I just would request a little bit more clarification on those choices, the choice of, you know, of granting a variance
Yeah,
versus going the equitable estoppel route.
right,
And
okay.
what are the ramifications with each?
Okay, well, one thing I guess I still have a little bit of confusion with in my mind is if we go the administrative appeal route, are we limited with regard to evidence? You know, with the evidence that we consider, with the facts we consider, because our ordinance says that we have to just consider the facts that the code enforcement officer considered. That, you know, we can't do this as a de novo appeal. Whereas if we do a variance, we can consider all the factors. You know, that, I don't know in this case because, you know, we wouldn't be looking to find the decision of the code officer in error. If it applies in the same way, I'm not sure because, I haven't been part of an appeal where we've used this tool that's being suggested with regard to equitable estoppel. So, you know, for me, that's a little bit of uncharted territory. I certainly have appreciation for it from a legal perspective because I have been involved in other projects and cases where this principle has been demonstrated and has been applied. This idea of equitable estoppel and this idea of an entity having interest in a project because they have made prior investment for that legal argument being made. I guess the other aspect of it is looking forward, okay? So looking forward, this is a new zone, you know, might we have other appeals? Are we setting precedent? Are we setting, by using one tool or the other, are we making a statement with regard to precedent? Variance versus equitable
Not a lot
estoppel.
of people will have a letter like Jamie does. I
Uh-huh.
think that's a key factor.
Yes, so
Not a
in
lot of
some
people-
ways, that equitable estoppel method is more powerful, or maybe more favorable, because we're able to cite the letter. We're able to cite that letter. But you could also do that in a variance.
Yes.
You know, you could also do
Yes.
that in a variance. And which variance criteria is that? I can't remember. Is it like number 4 or C or something like that? It's that fourth one. That
Hardship
says
is not result of action taken.
Yes, not
by the
result of action
appellant
taken.
Or the prior owner.
So that's where it could be cited, okay? So I think you could do it either way. I think you could do it either way.
That's my sense.
Yeah.
My question would be, since we have no attorneys on the board, how do we word the equitable estoppel easement,
Yes.
or whatever the right word is?
Exactly, so a
And-
variance,
We could take
Yeah.
Larry's wording,
Mhm.
I'd be happy doing that, but we probably want to submit it by our attorney, I assume.
I don't know that that's up to you.
Yeah.
But I think I think the wording could go into number 4 for sure.
exactly, so in a way, of the variance it's a tool that's already, it's an outline that's already there for us with regard to a legal.
Can we go
framework.
down, can we, like last time, go down?
Well, we don't have to do that if we're going equitable estoppel.
Right.
No,
But
but
maybe we look at the variance first.
we look at the variance criteria, we go through the variance criteria?
I'm curious
Yeah.
if we do the estoppel route, can we take into consideration their costs
Yeah,
after the fact? After the determination letter, can we, because I didn't see all that.
well, exactly,
So
That's
with
my-
equitable estoppel, I don't know
Yes.
that you can look at the things that they presented.
yeah,
So I think if you're interested in that, you need to look at a variance, because
Yes.
in a variance, you can look at all the fees that they've spent. But in equitable estoppel or administrative appeal, you can't,
That's right.
exactly.
because it's only what I have, and I didn't have all that.
Exactly,
that
he didn't have all
determination.
that when he made his decision. You can only look at the facts that were on the table at the time for the code officer. Yeah.
I don't know that.
It says
It's
it
in
in
the
the-
ordinance, yeah.
I don't see an equitable estoppel in the ordinance at all.
No,
Well,
it's-
but it would
but
be
that's
under
a type of
administrative
administrative appeal.
Yeah, there's no equitable estoppel option, really. It's just
No.
either it's an administrative appeal or it's a variance.
Yeah.
Yeah.
Yeah, and there's two types of two types of variance. Those are the only two appeals that you guys can
Exactly.
see.
Yeah. From that perspective, it kind of makes sense to me to do what Byron suggested,
Yeah.
which is to go through the variance criteria and see where we land. Yeah.
All we have to do is approve all four of those,
Mhm.
and she's good to go.
Yep.
Yeah.
You need a motion to do that, right?
I don't think so. Well, the applicant has, or the appellant has said that they would be satisfied with either. So why don't we go through the criteria? I don't think I need a motion to do that. Okay. So I probably could use some assistance, so I'm gonna have to pull up the ordinance here.
I have it here.
Oh, excellent.
All right,
So-
Okay. And we're gonna read these in consideration of really Terry's experience on this board and his wisdom. We're gonna read these word for word, each
Well,
one.
you change it, then you change the ordinance.
Exactly, so, thank you, Terry. So if you could help us with that out, if you could
Yep.
read each one, go through, and we will go through them.
You want to read them?
Okay, so I can read it if you like.
If you give the number.
Yep.
Start, give
So-
us the whole thing.
This is under powers and duties of the Board of Appeals. Administrative appeal is A, we're talking about B, variance appeals. To authorize variances within the limitations set forth in this ordinance. Number one, dimensional variance. The Board of Appeals shall not grant a variance from dimensional requirements unless it finds that A, the proposed structure or use would meet the performance standards of this ordinance except for the specific provision which has created the nonconformity and from which relief is sought. And B, the strict application of the terms of this ordinance to the petitioner and the petitioner's property would cause undue hardship. The term undue hardship, as used in this subsection, means.
Okay, do we want, I just want to make sure we're not going too far.
Okay.
Do we first want to make a determination with regard to whether or not this project would meet, or this, this proposed project would meet all the other terms of the ordinance, except for this specific dimensional provision?
Yes.
Okay, and your statement is yes, it would.
And my statement to that is yes, the request would be allowed except for this
Dimensional issue.
dimensional issue.
Okay, and so is the board in agreement that is the board in agreement that, what the appellant has proposed here would meet all of the requirements except for this dimensional provision?
And the dimensional provision is the 40,000
Yeah.
foot envelope.
Exactly.
Is the part that I.
So sounds like we have agreement on that, is that correct?
She already meets that, right?
Okay, so all those in favor? I just like, I'm just
Yes,
trying to
yes.
document this. Okay, all those in favor, please raise your hands. Okay. All right, so no one opposed, 4-0. All right, what's the next one?
So that was number 1A.
Okay,
5-0.
5-0, thank you.
Number 1B is the strict application of the terms of this ordinance to the petitioner and the petitioner's property would cause undue hardship, period. The term undue hardship, as used in this subsection, means these 4 items.
Okay, we're gonna vote on these individually.
Mhm.
Okay,
Number 1.
yep,
The land in question cannot yield a reasonable return unless a variance is granted.
So moved.
Yeah.
Second.
okay, all those in favor?
Yeah.
All right, 2,
Number 2, the need for a variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood.
So moved.
Second.
all those in favor? Number 3,
This is B3. The granting of a variance will not alter the essential character of the locality.
So moved.
Second.
All those in favor?
And number B4, the last one, the hardship is not the result of action taken by the applicant or the prior owner.
So moved.
So I think before we vote on this, I'd just like to add a little bit of language in there if we could. And I'd like to make a motion that we approve, let's see, what is that, 1B3? 1B4, yeah,
B4.
based on the fact that, that the appellant was issued a letter from the code enforcement officer on March 8th saying that she could, that the lot was developable, and that based on that letter, she, based on that letter, she entered into obligations with the seller and also with others, and therefore has an interest, developed an interest in the property prior to the zoning changing, something along those lines. You know, maybe you can iron that out a little bit in minutes.
And the ordinance changed.
Exactly, and the ordinance changed. Yeah.
So were you adding that?
What's that?
Were you adding that?
Well, I want us to, I think we need to document in the decision. I'd like us to show in the decision, so if somebody goes back and looks at this, why we approve this.
Actually, they're kind of two different things. We're voting on B4,
Yes.
but we need to document why.
Yes, yes, and,
For the
you know,
record.
here's the challenges. I go back and I write that. I can't just make it up, you know. We need to state it for the record. So otherwise, we need to convene and review the decision. So, you know, we need to say for the record in this meeting why it is that we're approving 1B4. So
Well-
that's what I'm trying to do.
Wait a minute,
Yeah.
okay. You cannot change the wording of that because then you've changed the ordinance.
Okay, so we got into this
But
before.
after we voted on this, you can make that in your summary as to why 1, 2, 3, and 4 passed or failed or whatever.
Okay, that's fine, I'm happy with that too, Terry. So, all those in favor of 1B4? Okay, so now, in summary,
So the wording didn't change, you voted on that,
Right.
but
Yeah.
it's the summary that is the important part for the
in
record.
summary,
Exactly, the way, if I may,
yep,
okay? If you start changing this, okay, you've changed the ordinance.
Yeah.
And we don't have the authority to do that.
right, well, I'm definitely not
As
trying
much
to
as
do
we'd
that.
like to, we don't have the authority.
Okay, so in summary, for the record, help me here, why are we approving 1B4?
It's actually B4, so it's
Yep.
B1, B4.
If I may.
Okay, yes,
I would say that the way I feel about this is, this property lot, or whatever you wanna call it, was basically done before town meeting.
okay,
So basically, it was done before town meeting, and maybe I'm using the wrong word, but I
Okay.
would almost think it would be almost
I don't like
grandfathered.
the word done.
applicant had a vested interest in the property,
Equitable
or
interest.
equitable interest, I thank you,
Advanced.
equitable.
Okay,
Okay,
Interest.
add an equitable or demonstrated, okay. Okay, so the applicant demonstrated an
Because this process was started way before town meeting. March 8th, is that what it was?
February, I had the survey done in
Prior
February.
to town meeting. And based on the code enforcement officer's letter of March 8th.
And I think, for the sake of the board, that really does limit any precedent to something that occurred prior to the ordinance change.
Right. Okay. Very good. So, all the criteria have been satisfied for variance. And so I'm not sure if we even need a vote to officially grant the variance.
Yes.
You think we still do need a vote?
I think you should vote.
Okay, yeah. All right, so all those in favor of granting a variance?
Well, don't we have to approve the appeal?
No, we have to grant it, well, we are. By granting a variance, we're approving the appeal. It's the same thing.
Approving the request.
Yeah.
They requested either a variance or an administrative appeal.
They covered both bases, they checked off both.
Right, but we're doing the
Yeah.
variance.
It's an either or, it's not both. And so we've done the variance.
Right.
Yeah, so all we need to do is just, it's just a formality, really, to say that we approve the variance. Yeah.
Great.
Well, we should come up with a wording for what the variance is. The variance is, we are allowing Jamie to build on what?
In the 40,000 foot building envelope without regard to the resource protection of that lot.
Okay, so we're regarding a variance from the dimensional requirement
Yes,
of the building envelope.
yes.
I think that's all we need to
Yeah, okay.
say. That may be all we need to say.
I think so.
What do you think?
Yep.
Variance for the
Uh,
envelope requirement?
For the dimensional requirement of the
Yes.
building envelope. We're approving a variance from the dimensional requirement of the building envelope.
Yeah, that's specific, because that doesn't waive anything to do with the floodplain.
Which is
Yeah.
section 4(1)(a)(1)(a), building area. For the resource protection,
Nope.
No, just a variance for section 4.1 district requirements, A1A, minimum buildable area, is the contiguous 40,000 square foot building envelope, which is not in the resource protection district.
okay, so I'll just copy that when I
Yeah.
type it up.
Okay, so, I make a motion that we approve a variance from the dimensional requirement of the zoning ordinance
So moved.
for the appellant.
I second it.
All those in favor?
Board, thank you very much, and thank you for your very careful consideration of the issues. It's very interesting.
All right, yes, we wish you luck.
We tried our figure in it.
Is there anything that statement is when I come back?
You'll get a determination, so
Yes.
you'll get a determination
Okay.
from the chairperson.
This one's only gonna be a page.
Yes, thank you. So a determination,
Right.
and I will get that to you, I need to get that to you within, I believe it's 7 days.
Okay.
And she
And
had
I'll
any kind of a time limit now to apply for a building permit?
No, but I would apply for a building permit as soon as possible.
Yeah.
Tomorrow morning?
You should wait till you get the letter. But,
Right.
So, yeah, I'm losing concentration here.
7 days.
You'll need to get that, and I'll send that, either you come and sign for it, or,
Just-
so I'll have to wait till I get it, or certified mail. So coming to sign for it would be a quicker way to do it.
Yes.
Yeah.
Just let me know.
Yeah,
Yeah, we'll have that for you in just a few days, the
Yeah.
decision.
great.
Thanks very much.
Thank
You're
you
welcome.
guys very much. Thanks for
Yeah.
your time.
Okay, we gonna
Hate to
adjourn?
keep meeting you
Oh,
here.
yeah.
Oh, yes.
Motion.
Yeah, yeah.
Make a motion to adjourn.
So,
Second.
okay, all those in favor?
Guys.
All right, we are adjourned at 7:25.
TV.
7:25
Nice
for
to
the
see you,
minutes.
Larry.